Good evening. Happy Monday. Our boy Chillie's been at it again. This is a filing that he did. I don't think he intended for it to be filing. This is an ex parte communication with the court. He wrote a letter to the judge because that's what you do when you're a constitutional law scholar. You understand all about ex parte communications with the judge. Anyway, he says, Dear Judge Burroughs, subject to Castro versus Abrams et al. I'm writing in response to the continued status conference held on Monday, October 24th, 2022. At the conference, Your Honor asked all parties to, number one, preserve all relevant evidence. Number two, where possible, have our associates stand down from any harassment. These orders did not make it into the written order filed in the record, and defendant Peters's camp and defendants Peters's camp is relying on this. They claim that there are no such aforementioned orders, relying on the technicality of case law on the effectiveness of orders. Case law is just a technicality, apparently, according to our constitutional law professor. Case law, that's just a technicality. Just a technicality. You know, those technical details. Case law, stare decisis, Supreme Court decisions. These are all just technicalities. As the plaintiff in this action, I pray for the court to clarify whether the aforementioned orders were amended out of the written order on purpose or by mistake, and to make any additional orders where appropriate. I'd like to file a motion to have additional orders made, except I don't want to title it a motion or give opposing counsel notice or even give opposing counsel a copy. I'm just going to write a letter to the judge because that's what you do. Don't you know? I'm an expert. I don't want to be the only party following your Honor's oral orders, but I also was relying on these orders when not objecting to the tabling of my motion against spoliation and not filing the preliminary injunction that I am drafting in the fashion of an emergency motion. Respectfully submitted, Jose de Castro, pro se. I hate to break this to you, Chillie, but she didn't order the parties to preserve all relevant evidence. She noted that the parties have ongoing duties imposed upon them by the federal rules of civil procedure to preserve evidence. It's an ongoing duty. She doesn't have to make that order. Both parties have that duty. I only know of one party, however, who has deleted an entire channel worth of content. And I'm not going to point any fingers, but I think that party's name has a small d. And this part, I believe, if I remember correctly, the court asked if the parties would be willing to agree to a, quote, ceasefire, end quote. And I believe that after Kate's attorney discussed it with Kate, that her and her attorney attempted to agree with you. They posted an update to the judge about how they attempted to agree with you on the ceasefire, and that your dumbass would not agree to the ceasefire that you're now asking the court to turn into an order because you're that level of stupid. Christ almighty. Whew. So that was his ex parte communication. And now we have a motion. This is a motion to transfer venue filed by ya boy, Jose Small D de Castro. I, Jose de Castro, plaintiff, hereby move this honorable court to transfer this action to the United States District Court for the Southern District of California. I just want to point out that Chillie does not live in the Southern District of California. He lives in Southern California, but LA and Santa Monica, where Chillie lives, is in the Central Division of California, not the Southern Division of California. So Chillie, being the constitutional professor and legal genius that he is asking the court to transfer venue to a district where none of the parties resides. 'Cause that's what you do. Pursuant to 28 U.S.C. 1404A, on the grounds that the convenience of the parties and the witnesses and the interest of justice would be best served by the transfer. The majority of witnesses and evidence are in Southern California. In support of this motion, I incorporate the attached memorandum in support. Now, normally what you would have to show, I have not read the entire. I've gotten down to about this far. Normally, what you'd have to show is make some prima facie showing of, number one, that the court would have personal jurisdiction over the defendants at the venue you're seeking to transfer the case to. That's number one. Number two, you would have to show they would actually that there are more witnesses, and what those witnesses would be. Basically like, I have 3 witnesses to this act. Normally where this happens is like something like a car accident. Let's just use a car accident for an example. If Kate and Josh were each driving a car in the Southern District, apparently, of California, and they each ran into Chillie's vehicle, right? Then the court might have jurisdiction over them in Southern California, number one, because that's where the accident happened. That's where the thing happened. They were in California. They damaged Chillie while they were in California. And Chillie might be able to say, these were the witnesses are, because there were 3 witnesses who saw this accident, and they all live in Southern California. And he would be able to say, it's, witness A, witness B, and witness C, and they all saw the accident, and I intend on calling them at trial. And that would make sense. The court would be like, oh, well, that totally makes sense. We ought to transfer it to Southern District of California because that's where the witnesses are, right? Interest of justice would be totally behind that because that's where the witnesses are. Now, I might be dumb. I probably am dumb. And no, I'm going to say it. I'm dumb. I'm just a first-year family law attorney. And I know that the witnesses to this alleged defamation are scattered throughout the country, throughout the world. I get people commenting on my videos from all across the world. Mainly U.S.-speaking countries like Australia and England, but all across the world. I don't think that there are particularly more witnesses in Southern California, and we're going to see if he actually names any witnesses or describes fairly any witnesses in Southern California that are going to be necessary to him making his case. Because remember, a witness is only useful if they help establish a fact. And I don't know that he needs one for this, but we'll see. And then as far as personal jurisdiction is concerned, personal jurisdiction, there's general and there's specific jurisdiction. General is like if you could just sue somebody for anything in that particular state. Like California has general jurisdiction over me because anybody could sue me for anything in California because I live here. Anything you want to, you could sue me over in California. Not a lot I could do about it because California has general jurisdiction over me. Now, specific jurisdiction is different. Specific jurisdiction is something like where Kate and Josh were driving through Southern California and they ran into Chillie's car. For the purpose of that accident, California would probably be appropriate. Personal jurisdiction. They can get personal jurisdiction over Kate and Josh in California. And that makes sense, right? That makes sense because they're there for that one thing. But you can't sue them for anything. I mean, you can't sue them for, I don't know, unpaid child support in California because they haven't made themselves residents of California. California doesn't have general jurisdiction. I mean, they wouldn't expect to be sued over anything in California, but they would expect to be sued over the car accident that they had in California. I hope that makes sense. So let's see his memorandum in support of motion to transfer. Now, before we get in there, this is what he's referring to right here. For the convenience of the parties and witnesses, in the interest of justice, a district court may transfer any civil action to any other district court or division where it might have been brought, or to any district or division to which all the parties have consented. So unless Josh and Kate consent to it being brought in the Southern District of California, unless they do that, Chillie's going to have to prove, number one, that it is more convenient to the parties and witnesses. And between the parties and the witnesses are by far the more important of the two. So he's going to have to prove that it's convenient for the witnesses, that it's never going to be convenient for the parties. It's always going to be it's going to be just shifting the inconvenience from one party to the other, generally speaking. But in this case, neither party lives in the Southern District of California, so he's going to have to prove that it's going to be convenient for both sets of parties. He's going to have to prove, number 3, that it's in the interest of justice. And that's a big, important one. It's got to be in the interest of justice. And he's going to have to prove the 4th thing is that it could have been brought in the Southern District of California. Let's see if we get there. This case presents a clear set of circumstances. I work for an attorney. I could always tell when he has a really shit argument where he doesn't have good facts to support what he's saying, because he'll start off with clearly this. It never fails. If I say we can't do that, he'll say, well, clearly we can do it. And at that point, I know he has nothing. He has got no argument. He's saying clearly. You never want to tell the court clearly. The court understands what is and isn't clear. You telling the court that it's clear doesn't help anything. It doesn't help the court. It doesn't help you. It's probably going to irritate the court, honestly. It'll probably irritate the court to have you tell the court what's clear when it's not in fact clear. Show the court the facts, show the court the law, and let the court figure out if it's clear or not. This case presents a clear set of circumstances weighing in favor of transfer to the United States District Court for the Southern District of California, where lies, the source of the defendant's defamatory statement. The defendant's defamatory. First of all, I assume there are multiple defamatory statements, number 1. Each defendant has allegedly made defamatory statements, and I don't believe either of them made those statements in the Southern District of California. The domicile of the injured plaintiff. I believe the injured plaintiff, let's look this up. Southern District of California. Let's go to images. See if we can get that nice and big. All right. So San Diego and Imperial counties are the Southern District of California. The Central District contains Orange County, Los Angeles County, San Bernardino, Riverside, Ventura, etc. So I believe that Santa Monica is Los Angeles County. Santa Monica, California. Santa Monica, California is in Los Angeles County. Los Angeles County is Central District of California. So there's that. The location of the majority of the video evidence. I believe, and I could be wrong, that YouTube is in, I believe YouTube is in the Northern District of California. Images. Images. I believe they are in Santa Clara County, I believe, is where they're located. And so I believe that they are Northern District. I believe they're Northern District. Maybe they're not. Maybe they're located in Los Angeles or something like that. Maybe they're central. I remember when Earl sued me. He sued me, the Hemmings, YouTube, Lisa Richard, and several other people. Texas Wolfman, some other. Anyway, he sued a bunch of people, and he sued in the Central District of California. And I thought that was weird at the time, because YouTube was located, I think, in Santa Clara County, which is Northern District. So anyway, the videos, if they are located anywhere, they would be located in the Central or the Northern District of California. But what do I know? I'm just a first-year family law attorney. The majority of the jurisdictional records related to the defamation. I have no idea what the hell that is. I don't know what that is. The majority of the jurisdictional records related to defamation. You stumped me on that one, Chillie. You got me. And the majority of the witnesses for the defamation. Ooh, I can't wait till he shows that. Relevant background. The primary defendant for the defamation, where there can be one, is Catherine Peter. Now, why didn't you name her first then, if she's the primary defendant? And what the hell even is a primary defendant? I don't even know what that means. That doesn't make any sense. You're using words. I understand every single word you're using, but when you put them together like that, they don't make any sense. Peter allegedly, that's a very strong statement, sir. You're really selling the court that you believe this. Interviewed witnesses in Los Angeles. In Los Angeles, which is, again, Central District of California. Basis or defamatory statements on alleged jurisdictional records. What's a jurisdictional record? I don't know what a jurisdictional record is. Does he mean like a judicial record? I think he means judicial. I'm going to go out on a limb and suggest that he means judicial records. The majority of the judicial records related to defamation. Basis or defamatory statements on alleged judicial records issued by, that doesn't make sense, issued by Los Angeles parties. What parties issue, like which part? The only party to this case that is from Los Angeles, or at least the Los Angeles County, is you, Chillie. You issued jurisdictional records? That doesn't make any sense. I feel like I'm taking crazy pills sometimes when I'm reading this guy's pleadings. And raises defamatory issues that allegedly occurred in Los Angeles County, California. And raises defamatory issues. What's a defamatory issue and how do you raise it? So Peter raises defamatory issues that allegedly occurred in Los Angeles County, California. That sounds like it makes sense, but that doesn't make any sense. Peter makes defamatory statements about alleged activities that allegedly occurred in Los Angeles County. Again, that's Central District of California, but okay. And then he says, defendant Joshua Abrams is an associate of Catherine Peter. What does that mean? Now, I understand what like an associate is, hey, this is my associate. I'm associating with him. But that's like if you're going for respondeat superior, if you're trying to say that Joshua Abrams is an agent of Catherine Peter, and therefore Catherine Peter is responsible for his actions, you would say that he's an agent of Catherine Peter. That she's the principal, he's the agent. Not that he's an associate. Like, you're not responsible for the actions of associates. So I don't even know. I don't even know what that's supposed to mean. I don't even know why he's alleging that. That doesn't make any sense. I, plaintiff Jose de Castro, originally filed this action in the United States District Court for the District of Massachusetts. Since then, I have been prejudiced due to lack of access to court terminals for transcripts, lack of the ability to physically submit video evidence to the clerk, video evidence being the majority of the evidence that will be filed in this case. You don't, how do I put this? You don't file evidence, Chillie. You dunce cap. Dunce cap. Dunce cap. I can't do him. I can't do his dunce cap well. You submit evidence at trial. So when you go to trial, because no one looks at the evidence until trial, Chillie. Trial is where evidence gets introduced. And you submit the evidence at trial. You basically build a foundation for the video. You provide the witness testimony to authenticate it or what have you. And then you submit the evidence to the court. And assuming the evidence gets past any objections that the defendants may raise, then the court will accept that evidence into evidence. They'll accept the video into evidence. And then it will be part of evidence. Then it's actually evidence. Then it's something that the jury can consider as evidence, or something the court, if this is a bench trial, the court will then be able to consider it as evidence. This isn't something where you're just submitting stuff and the court is going to just sit down there and watch your videos, you dunce cap. The court doesn't adduce, or they don't take evidence until trial. So you don't have, and I don't know what access to court terminals for transcripts means. I don't know what that means. The Pacer is where you get the transcripts. I don't know why you lack. So he says that he lacks the ability to physically submit the video evidence to the clerk. But I just want to flip this around a little bit. If, for example, there was a court terminal where you would get transcripts, then Kate and Josh would be prejudiced by it. If you had to physically submit video evidence to the clerk, which is just stupid on so many levels, then Kate and Josh wouldn't be able to. But you don't have to physically submit it. You can mail it in. I think I've never uploaded, because I'm not dumb enough to try to upload my evidence prior to trial. I don't know why you would do that. It just doesn't make any sense. But you don't need to. You don't need to. You just don't need to. I mean, if you're submitting like an affidavit, like trying for a motion to, like a motion for some sort of a injunction or some sort of a pretrial relief of some sort, maybe, but I don't really see you having to submit videos. The court's not going to sit down and watch your videos, dude. Witnesses that Peter allegedly spoke to and that I will call in my defense will mainly be in Southern California. Southern District of California? And who are the witnesses? Who are these witnesses? How many witnesses are there? One witnesses? Two witnesses? And what are they going to testify to? That Kate Peters spoke to them? Does that prove defamation? Are these witnesses going to say that Kate Peters defamed you? Or is this intentional infliction of emotional distress? Is somehow what Kate Peters said to these alleged witnesses, did that cause you emotional distress? And can you prove that it was intentional? The majority of the judicial records and agents reside in Southern California. So now we're on judicial records. So maybe he wasn't meaning judicial records when he was talking about jurisdictional records. Maybe he was. I don't know. The majority of what judicial records reside in Southern California? And what are you talking about agents? What do you mean when you say agents here? We've already determined that Josh Abrams is an associate, apparently not an agent. What agent are you referring to? Doesn't make any sense. It says the case should be transferred pursuant to 28 U.S.C. 1404A. As this S Court has held, the relevant factors for determination of whether to transfer venue under 28 U.S.C. 1404A include, number one, the plaintiff's choice of forum. Well, the plaintiff already had his choice of forum, and you chose the forum by filing in the District of Massachusetts. You chose. Normally where this comes up is the plaintiff files in a district that the defendants don't like. And so then the defendants try to transfer the forum. And the court would then give weight, not a lot, but they would give weight to the plaintiff's choice of forum, because the plaintiff gets to choose where he files his lawsuit. And so it's going to weigh into it. But the plaintiff in this case chose to file in Massachusetts. You dummy. Number two, the convenience of the witnesses and the location of the documents. I don't recall this. I know the convenience of the witnesses weighs very strongly, but so far we just have that allegedly Peter spoke to some witnesses that are in Southern California. We don't know who or how. The law to be applied, yes. The connection between the forum and the issues. Yeah, that's a good one. The connection between the forum and the issues. What is there? I don't know. Probably none. The state or public interests at stake, and the relative convenience of the parties. But that always flip-flops. Now, why do we go back to 2010? What do we got here? What do we got? Might be important. No, I did not get anything important. And he chose a district court decision, Thermo-Niton Analyzers versus Morningside Cap, LLC, but it is from the District of Massachusetts. As more fully addressed below, each of these factors heavily favors granting plaintiff's transfer. B, potentially relevant witnesses. Not relevant witnesses, mind you, potentially relevant witnesses. And documents are largely located in California. The convenience of witnesses, probably the most important factor. It is probably the most important factor among those considered by the courts. Again, from Massachusetts. Good job, buddy. Good job. Again, these are, since these are district court cases, they are not binding. They are, they're persuasive, but they're not binding. The convenience of the parties, the convenience of the witnesses strongly supports granting plaintiff's motion motion to transfer the Southern District of California, and this district provides virtually no benefit for witness convenience. That's it. The most important factor gets 2 sentences. The most important factor he gives 2 sentences to. That's really freaking weird, because see, I could already formulate a response by Josh and Kate. They're going to talk about the res judicata of the 2 Massachusetts court decisions denying DeCastro HPOs. They're going to talk about the witnesses at the event where DeCastro was online, where he ended up assaulting Kate Peter. What else? Yeah, those are the witnesses that I think they would call, or they could potentially call. Excuse me. And so now we have unnamed people who allegedly Kate called, who he might call for trial. That's going to be interesting. California law likely applies, not Massachusetts law. That's true. California law does likely apply, but that doesn't mean you get an automatic transfer of venue. Southern District of California is proper a proper venue. It's proper a proper venue. It's right proper. My English accent is terrible, and I apologize about that. For the convenience of the parties and witnesses, in the interest of justice, the district court may transfer any civil action to any other district where it might have been brought. So this is where he's going to talk about where it might have been brought. Accordingly, the district court may transfer an action to another district pursuant to 1404A if two requirements are met. Okay, which two? First, a court must determine the action might have been brought in the transferee court originally. Okay. This action could have been brought in the Southern District of California. That's what you got? That's where you're going to establish personal jurisdiction? That's where you got? It could have been brought in the Southern District of California because why? Because why? Indeed, where it might have been brought is important. FRCP, I think it's 4. Let's try 4. I think it's 4. I thought it was 4. Is it 3? Maybe it's 4. Oh, why am I blanking on this? I thought it was. I thought it was up in here. Venue generally. Anyway, I'm sorry. So, no, I'm not going to edit any of that out because I don't have the technical skill. So I like to use district court decisions to get a good summary of what other case law has provided. And this is Brown versus Dash, a district court out of Massachusetts decision. And I chose it because it's relatively new, 2020. And they talk about two things that I find are helpful. There's general jurisdiction. This is where I was talking about how California has general jurisdiction over me. I could be sued in California for anything and everything because I live in California. They have general jurisdiction over me. My affiliations with the state are continuous and systematic to render me essentially at home in the forum state. And that's International Shoe versus Washington. Now, there's also specific jurisdiction. And specific jurisdiction, you've got the long arm statute. And California's long arm statute goes to the same extent as allowed by the Constitution. So it's the same extension that the Massachusetts one is. So the district court can sidestep the statutory inquiry and proceed directly to the constitutional analysis. So due process requires the defendant over whom the court seeks to exercise jurisdiction has maintained minimum contacts with the state such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. The minimum contacts analysis has 3 categories: relatedness, purposeful availment, and reasonableness. So the first question you're going to ask is, how related is the underlying suit to the forum state, to the state that he's trying to get Kate and Josh into? How related are their statements to California? Now, I believe that they picked up on Chillie. They started making videos on Chillie when he was in Ironton. I think that's really where he kind of burst onto the scene. Ironton, Ohio. And he did stuff in Arizona. He did stuff in Oklahoma. He did stuff in Massachusetts. He did stuff in Denver, Colorado. He's done stuff in Arizona. He's done very little in California. So how related is what they did to California? Not very. Did they purposefully avail themselves of California? They didn't. I mean, you could argue that Kate making the phone calls, if she did, to people residing in California might be related to the defamation. Might be her availing herself of California. But is that going to be enough? And the court would have to look at reasonableness to figure that out. Is this reasonable to do this? And I don't think that's going to weigh very heavily for Chillie because, number one, he's asking for the court to transfer the action to the Southern District of California, which is, again, not what he really wants. He really wants it to be transferred to the Central District of California. But one of the things that I find very interesting in this particular case, what they do discuss, the purposeful availment, they discuss the relatedness. And under purposeful availment, they talk about the fact that Kate and Josh threw this stuff up on the internet. And the principles of the purposeful availment apply to internet activity. The mere existence of a website that is visible in a forum is not enough by itself to subject a defendant to personal jurisdiction in that forum. Given the omnipresence of internet websites, such a rule would eviscerate the limits on personal jurisdiction over out-of-state defendants. Courts have been reluctant to find the purposeful availment prong satisfied where, as here, the only link between an out-of-state defendant and an in-state injury is a website or internet posting that in-state residents can access, especially when the defamatory posting makes no mention of the forum state. And we're getting a whole bunch of different examples of it. Similarly, none of the publications that plaintiff alleges reached Massachusetts audience, Similarly, none of the publications that the plaintiff alleges reached Massachusetts audience, the Instagram posts, the video posted on Instagram and the World Star Hip Hop site, and the Breakfast Club radio show interview that was published on YouTube, radio, and a cable channel, were designed to specifically engage or solicit Massachusetts audience, or even referred to a plaintiff's law practice in Massachusetts. The mere fact that these posts were visible in Massachusetts, as they were in all 50 states, is insufficient to show purposeful availment. So you can see the kind of analysis that the court is going to use for purposeful availment. And anyway, long story short, and I'm sure that this has already been a long story made long, and I apologize about that, is that he did not really brief this very well. He doesn't really address anything very fully, and he certainly doesn't address the personal jurisdiction that is required to transfer this to the Southern District of California. He doesn't even make an attempt to. Anyway, thanks for watching. Have a great day.